Hey everyone, this is Eddie and welcome to this review of question number 3 of the California bar exam that was administered in July of 2017. Let's go to question number 1. It says, what is the likelihood that Rick will obtain a temporary restraining order? Let's go to that now. So what are the elements there? It requires an emergency and that it will result in irreparable harm. So let's fly through these because there are some meaty parts we want to get to. So emergency, Sam, the seller, did state that he was going to make the sale to another person, and he's pretty ticked off, right? So I think that element is met there with no problem. Irreparable harm. So this is present when the final judgment could be entered and the harm has already been committed. So here again, the chess piece can be sold at any time. And I think that element can be met by Rick. So Rick can be granted a TRO. Let's go on to question number 2. It says, what is the likelihood that Rick will obtain a preliminary injunction? Let's go to that now. That requires a showing that irreparable harm will occur. The likelihood of success can be met, and the discussion of the balance of hardship. Let's go to irreparable harm, and that was discussed earlier. Rick will prevail there. The likelihood of success. Decisions at the preliminary injunction are less formal because the complete record is not there. So courts usually apply a likelihood test. Number 1, how likely is it that the plaintiff will prove his claim? And 2, how likely is it that the plaintiff will likely withstand the challenges? Rick will be able to prove his claim. Why is that? Because there's a written contract that is present. How likely is it that he will withstand the challenges? I think it's going to be very likely because the facts do state that the parties entered into a valid contract. So that element will be met. Notice how discussion go in, go out, because there's major issues here. We want to get to those fast. Now let's go on to balance of hardship. Which party will suffer the most if the injunction is not enforced? So let's talk about Rick. So Rick's going to say that he's going to suffer the most. Now notice that the element wants to know if the injunction is not enforced, not if the suit is won overall. So Rick's going to say that he's not going to be able to attract people from all over the world because he's missing a piece on the entire chess set. But what is at issue here is not the entire chess set, it's the individual queen. That is not going to help Rick. Now, Rick will probably have to wait for a very long time for another chess piece, another queen piece to go on sale. Or that sale may never occur because the facts do state that the sellers there seem very unwilling to make a sale. So I think that it's going to impact Rick in a very tremendous way. So he might be able to succeed on this claim. Now, what happens if the court rules against Sam? So let's now go to Sam. Sam wants to show that he's going to suffer more if the injunction is not granted. He's going to say, hey, look, I'm going to miss out on a sale that's worth at least $175,000 as opposed to $450,000. So that's a substantial difference. But Sam is going to be able to have the opportunity to find another buyer after the injunction. So I think the balance of hardship here is going to favor Rick. He's going to be able to show that he's going to be more at a loss if the injunction is not granted. So Rick is going to be able to meet that element. So the overall conclusion there is that a preliminary injunction will probably be granted. Now, if you said otherwise, of course, you could always explain your reasoning, because again, the bar exam, they're not looking for conclusions, they're looking for a discussion on the facts. They're looking for your analysis. That's what they're looking for. So even if you did not state what I said, that's fine as long as you analyzed it. Let's go on to question number 3. What is the likelihood that Rick will obtain specific performance? Okay, so that requires so again, there's a lot of elements here. a valid contract, mutuality, feasibility, a showing of likelihood of success, inadequate remedy at law, and no defenses. Let's go through these individually. A valid contract, we already discussed that. That is met. Mutuality of performance, so both parties must be able to perform. So, for example, if one party lacks capacity, then that might show that mutuality of performance is not met, but that does not seem to be a problem here. That element is met. Feasibility, consider the difficulty of the court in supervising the order, administration, and cost. So here, what do we have? We have possession of a chess piece, and I think the court might not have any difficulty in the administration or the cost of enforcing that order. So that element is met. Number 3, a showing of likelihood of success. That was discussed earlier. That can be met. Inadequate remedy at law. So money damages must be inadequate, and unique property meets that element. When you have real estate there, that could be easily shown, but real property is not an issue here. So what we do have here is we have 6 queen pieces of a chess set. So that might be that it is not unique. However, Rick is going to say that no one person knows a whole set that was made by Anituck. But that's not going to help Rick. Why? Because the whole chess set is not at issue. What is at issue is that individual queen piece, not the complete set. So I don't think that Rick is going to be able to meet this element. Of course, you could argue otherwise. Again, the analysis is what counts. Now let's go on to the last element, no defenses. So in order for Rick to prevail, he must show that there are no defenses. Equitable damages, lashes or unclean hands, that doesn't seem likely. What about other defenses? What about fraud? What about mistake? Let's go to fraud. So if you made an argument for fraud or misrepresentation, I'm going to use them interchangeably. Let's go to that now. So we're looking for a misrepresentation. And here it seems as if there were 2 questions. Let's go to the first question, whether the chess piece was worth anything. And then we'll go on to the second question, which was whether $450 was a fair price. Let's go on to the first question, whether the chess piece was worth anything. Let's read the facts. It says, Sam Seller brought to Rick an Anituck queen he found in his attic and asked if it was worth anything. And Rick asked what Sam wanted for the queen. So Rick is not being silent. He's actually answering the question. He's answering by asking his own question. So he's indirectly saying that that the chess piece is worth something. So that does not seem to be a misrepresentation, a false statement. Also, there seems to be no special relationship, no fiduciary duties between the parties. And so I don't think there was a misrepresentation made there. Now let's go on to the second question here, whether $450 was a fair price. So again, we're looking for a misrepresentation, and on these exams that usually requires a false statement or an omission. But it can also require an assertion that is false. And what they were looking for here was whether the buyer had a duty to disclose the actual price. So a non-disclosure can be equivalent to an assertion. Let me say that again. A non-disclosure can be equivalent to an assertion. So was there a non-disclosure here? And the answer is yes, because the buyer did know the price, the actual price, but he did not disclose it. But this does not end the discussion. A party must act in good faith and in accordance with reasonable standards of fair dealing to avoid liability. So let's look at the question again. It says, Sam asked whether $450 would be fair. Rick replied that $450 would be fair. Notice that the word fair is used twice, and that is not by accident on the part of the bar examiner. So that's a tip off. So even if you did not mention non-disclosure and an assertion, but if you discussed fairness, I think you did extremely well. So let's go ahead and turn now to Rick, and let's show some facts that show that he was fair. Okay, here we go. So the next day, delivery was to be made, delivery of the piece. So Rick did not take immediate possession. So that could show fairness on the part of Rick. Also, the facts do not state that Rick was an appraiser. So again, no special relationship or no fiduciary duty. Also, the courts are less likely to impose a duty where equal access to information is available. So it could be that the source of information and the actual price is available to both parties, and nothing seems to stop the seller from the inquiry. Now, let's go to a showing of unfairness. So this goes, okay, so now we're going to talk about Rick and how he was not fair. All right. So Rick did immediately offer to write a check, and also the buyer and the seller did sign a valid contract during that same transaction. So there was no time for the seller to say, hey, look, I'm gonna go ahead and make an inquiry as to the price. None of that. Everything took place during the same interaction. So on this, you can go either way. You can make your analysis and reach a conclusion, and that's gonna show whether a misrepresentation, whether fraud is present. But however you decide, I think that there was no showing of an inadequate remedy at law, and I think that's gonna prevent Rick from being granted specific performance. Now let's talk about the issue of mistake, because Sam is going to argue that there was a unilateral mistake because he did not know the fair market value of that chess piece. As for the rule, you already know that. Let's focus on one element. So the contract will be voidable if the party does not bear the risk of mistake. So here, if he bore the risk of mistake, and then the contract is not going to be void. Let's look at some law here. So courts have found that the party does bear the risk of mistake where he contracts with conscious awareness of his ignorance. All right. So if he knows that he does not know, that is going to hurt him. And also courts have found that the party does bear the mistake where he is aware that he has limited knowledge about the facts, but treats his limited knowledge as sufficient. So he goes in, he doesn't know enough, but he says, hey, I know enough, I'm good. So here, Sam, he even acknowledges with his question that he doesn't even know if the chess piece is worth anything. So I think you could state there that Sam did bear the risk of mistake. So I don't think Sam is going to be able to succeed on a defense of mistake. So again, Rick is not going to be able to show that there is an inadequate remedy at law, and specific performance would not be granted. So I hope this helped. I hope you passed. Until soon.